sent to the Court of Justice by way of preliminary reference. So the German courts were unsure about the interpretation of certain national copyright rules which are within the scope of European harmonization, which have to be interpreted in the light of European Union law. Okay? In particular, the question how we apply certain limitations and exceptions to copyright law in the light of European Union law. And these are quite important cases. One of them already in the German courts for more than 10 years. Okay? And this is a music sampling cases. The other cases, at the basis of all these disputes is the question how we base within or outside of copy law the fundamental rights of freedom of expression and the fundamental rights in property, including intellectual property. So freedom of expression protected under the EU Charter of Fundamental Rights, the Fundamental Rights document of the European Union, Article 11 and Article 17.2 for intellectual property. We find the equivalence to that in the European Convention of Human Rights in Article 10 and the first article of the first protocol to the Convention of Human Rights. The difference there being that the European Convention of Human Rights is a human rights document of the Council of Europe, which is nothing to do with the European Union, but it's an international organization that comprises also countries that are outside the European Union. For example, Russia, for example, Turkey. But all the European member states are member to the Council of Europe and have signed up to the European Convention of Human Rights. The EU Charter of Human Rights is the human rights document of the European Union. It has only come into force in 2009. This is why the case law that we now have on fundamental rights based on the Charter is relatively new and fresh. And also the question on how we apply the European Charter in European Union law is quite a fresh question. Okay? And another question would then be, how do we reconcile conflicts between the European Convention of Human Rights and the EU Charter of Human Rights, although technically there shouldn't be any conflicts between the two of them. If you have questions on the relation of the EU Charter and Convention, we can maybe do that then towards the end of the presentation. But for the moment, remember that the EU Charter applies to European Union law. Every case, every dispute that arises under European Union law is also subject to the fundamental rights under the EU Charter. But of course, whenever you deal with EU law is applied at national level, which often means that national courts will, as a first instinct, look at national law, at national constitutions, at national fundamental rights, and as a first instinct will apply their own fundamental rights to a given dispute. In such a case, the main question would then be, when you have to interpret European Union law, especially when it comes to a conflict between two fundamental rights, expression and property, or when you talk about intermediaries, the right to privacy, the right to operate an economic undertaking, who is the body that makes the final determination where you tilt the balance, where you determine a proper balance between these two fundamental rights? Because the balance can, depending on which courts decide, fall at a different point within that spectrum that is possible. So the first question would be, which court is then determined to decide that? But the second question could also be, is this a question that the courts should decide, or is this a question that the legislator should decide? Can the legislator decide with determination where to strike that appropriate balance? If you think about copyright law, for example, when you talk about the balance between the rights of right holders and the rights of users of protected works, you instantaneously would think about limitation exceptions, right? They determine in which instances you are allowed to use a protected work without asking the right holder for permission. Okay? And there are a variety of fundamental rights implications. most importantly, always the right to freedom of expression in its different permutations. But also a question of right to religious freedom, right to family life, right to artistic freedom. So the question here being, is that something that should be authoritatively regulated by the legislature and the judiciary only applies it, or should the judiciary also have a say as to the balance between these rights involved? One example where the courts determine this balance are the United States of America, who don't have what we find in most European countries, a list of exceptions, but they have the fair use doctrine, right? A relatively loose standard which is applied by the courts on an ad hoc basis. But it's the court who strike the balance in every particular case. In the European Union, as harmonized by the European legislature, I'm always using the wrong clicker here, obviously, I should close this down, the majority of limitation exceptions, the balancing elements, are regulated in the so-called Information Society Directive in Article 5, which gives us 21 exceptions to the exclusive right in copyright law. One of them is mandatory, which means member states have to implement it. The other 20 exceptions, member states can implement into their national law, but they mustn't, which can have the effect that you might find an exception in French copyright law that doesn't exist in German copyright law. Right. So the member states, when the InfoSoc Directive was passed, had to decide which of these 20 exceptions they implement. Some member states said, we're just going to we copy and paste and take all the 20 exceptions, and some member states said, we're not going to change our copyright laws at all, but we will just keep the ones that correlate with some exceptions that we find in the Information Society Directive and just ignore the other ones. Which means that for a very long time, the United Kingdom, which still is in the European Union, didn't have a parity defense because they didn't bother to implement it. Which means that some other countries don't have a private copying exception, which means technically that you as a private individual are not allowed, at least theoretically, to copy a book from a textbook because there is no exception that would apply to it. Okay? And this, of course, creates many problems, especially when you talk about cross-border exchanges of works, especially in a digital environment. This is why the Information Society Directive has been highly criticized. And of course, if you think about the Information Society Directive, it was passed in 2001. And what has happened since 2001 is more or less the internet. In 2001, most people didn't know really what the internet was. Not many people used it, but nowadays everybody uses it on a daily basis. Even your grandmothers probably know how to use a mobile phone, right? Or a smartphone. The Information Society Directive doesn't or didn't know that certain developments would take place. And they certainly then didn't anticipate that some exceptions might become pertinent in the near future. But member states, until today, can only have in their national laws these 20 exceptions and the one mandatory exception. There are no other exceptions, with some exceptions permitted. Otherwise, they would violate European Union law. And I'll tell you in a minute why that is so. And a further aggravating factor is that exceptions under European Union law are usually subject to what we call a narrow interpretation. Okay? So there is no liberty for national courts to apply a flexible interpretation. They have to stick relatively closely to the wording of the respective exceptions. And only recently, some court decisions have taken a slightly more liberal interpretation to exceptions, and whether this is a trend that will continue is still up to discussion. We don't know, but there are some chambers of the court have interpreted limitation exceptions not only under this principle of narrow interpretation, but they also said we have to complement that with the idea that when interpreting limitation exceptions, we at least have to make sure that the object and purpose of the exception is being fulfilled. And there are a number of very, very interesting cases that discuss this particular. But if you want information on that, I'd gladly help you, but this would then distract from what we actually want to talk about. But as I already said before, copyright is so complicated in the European Union because we have this multi-level system. The European Union who legislates, but also the member state who have to implement the legislation. And in copyright, we have the particular problem that copyright isn't harmonized entirely by the European Union. But the European Union only harmonized copyright in the sense of certain exclusive rights, namely the right to reproduction, the right to communication to the public, and the right to distribution. It didn't harmonize, for example, an adaptation right. It didn't harmonize a performance right. Okay. These are still widely regulated by national law. But of course, if you harmonize certain exclusive rights and certain exceptions, that implies certain consequences. Also for other elements of copyright law, especially moral rights, that will then be influenced by the availability of certain limitations and exceptions. And that must also be taken into consideration when interpreting European Union law. And one of the Advocate Generals, Advocate General Spooner, was the first one recently to realize that. And we'll come back to that in a couple of minutes. So briefly, to do a recap on the structure of European Union law. In principle, the European Union has exclusive competence to harmonize European copyright law, which means the member states don't have the competence in the area of harmonization to legislate in the area of copyright law, unless they're instructed by the European Union to do so. Okay? There's an overriding principle in European Union law that EU law always reigns supreme. It always has hierarchy over national law. If there's a conflict between national law and European law always prevails. The purpose behind that is, if national law could overrule European law, the entire purpose of the European Union, which is to harmonize laws throughout the European Union to create a level playing field, would be impossible. Okay? The idea of the European Union law is a free market idea, to enable goods and services to move freely, and therefore to create similar rules that if you're a trader in country A, you know exactly which rules you will find in country B, because they have been harmonized by a central body, which is the European Union. And once the European Union has acted in a certain policy field, for example, in competition law, for example, in intellectual property law, national legislatures are not allowed to legislate in that area anymore. And this is called the so-called principle of preemption, which means that in the area of exclusive right and limitation and exceptions, in which the European Union has already legislated, member states are not allowed to legislate anymore. They can only legislate when the European Union passes new laws that have to be implemented. Okay? Which means the Infrastructure Directive has been passed in 2001. And since then, there has not been much activity in terms of legislation in copyright law that pertains to exclusive right and limitation exceptions. That means copyright law in the EU is frozen since 2001. There hasn't been a fundamental change. In other terms, the laws are outdated and they don't really cater for what even in 2001 they realized is the information society, the internet, digital uses of copyright protected works. And this is the main problem that we now face in the three cases that I will present to you. But before we go into these three cases, and we discussed it already, so this is more or less for you now, there is this overlooming structure of fundamental rights in the European Union. Fundamental rights have the highest status in the hierarchy of norms of European law. So the hierarchy of norms in the EU more or less looks like the founding treaties of the EU, which is the Treaty of the European Union and the Treaty on the Functioning of the European Union, basic principles of European Union law, which are unwritten and developed by the courts, including fundamental rights, but also now written down in the EU Charter by fundamental rights. And whenever the European Union acts, and whenever the member states apply European Union law, they have to have regard to fundamental rights. So if you apply copyright law in front of a national court and you interpret it, you have to give it an interpretation that is in conformity with the European Union law. And whenever you have a rule, and you of course know that as lawyers, a rule is never clear. There's always room for argument. But you would then have to apply the argument that is as much possible in conformity, or more likely in conformity, with fundamental rights. Okay? And you have recourse to the fundamental rights as interpreted by the Court of Justice of the European Union. And I also told you already that you often have a case that when a national court applies European Union law, they will, because that's what they will deal with most of the time, first look into national law, national constitutions, and national fundamental rights. And often, historically, the interpretation of fundamental rights in a member state, in a national jurisdiction, is different than the European Union would apply fundamental rights. Because the European Union comes from a market perspective, free movement of goods. And member states often take the constitutional perspective that is reflected in their history. If you talk about Germany, for example, we interpret certain fundamental rights differently than the European Union. We also have different fundamental rights that the European Union does not have. I can give you one example. In 2006, there was a case in front of the Court of Justice about a game called laser tag. You know what that is? You go into I've never done it myself, but my friends love it. You go into a dark hall and you shoot at yourself with laser guns. And when you hit somebody, something blinks or beeps or makes a sound, and you are virtually dead. Okay? In most countries, that is allowed. In Germany, we have the fundamental right of human dignity, first article of the Constitution. And in early 2000, a company wanted to open a laser tag facility in Germany, because Germans also wanted to play that. And somebody argued, no, you shouldn't be doing that because this is against human dignity. The European Union, however, said, no, this is the freedom to provide services, which is one of the 4 fundamental freedoms in the European Union. And therefore, you have to permit that. And then the German Constitutional Court said, but our problem is, we now have a collision between European Union law, free movement of services, and the most important article of our Constitution. Which prevails now? And the general principle is, of course, European Union law should prevail. Then European Union law would erode the foundation of the German Constitution, the right to human dignity. The background of that obviously being that the Germans twice in world history behaved really, really badly and committed gross atrocities. And this is why we don't like shooting at people, even if it's virtually. No? We don't want to foster a tradition or a simulation of violence. This is why we're very sensitive in this particular area. In this particular case, the Court of Justice says, okay, we make an exception because it's such an important element of your public policy. In such a limited area, we can allow that you violate European Union law to give effect to Article 1 of your Constitution. Okay? One of, I think, 3 or 4 cases where that ever happened. But in principle, European Union laws for the interpretation of fundamental rights would be first European Union law and then second national constitutions. Or national constitutions, probably not at all. And the last and final arbiter of the application of fundamental rights in the EU is the Court of Justice of the European Union. And it is said quite clearly, whenever European Union law applies, European fundamental rights apply. So if you operate within the scope of application of the Information Society Directive, national law that is based, that implements the Information Society Directive, fundamental rights of the European Union are to apply and no other fundamental rights. Any questions in so far? Okay, so now we had in 2017, in May 2017, 3 cases referred by the highest German civil court, staffed by at least mildly able judges who have a certain intellectual background, who had certain questions about the application of the limitation, the exceptions, but also exclusive right of the Information Society Directive as implemented into German law. And all these cases dealt with the intersection, bless you, with fundamental right, freedom of expression, and the right to intellectual property. And we go through them one by one, and then we'll try to develop and I still haven't developed myself, the way fundamental rights might very well develop in the future in relation to copyright law. And one qualification here, these cases aren't done yet. Okay? What happens in the European Union when a court comes to the court of justice, a case comes to the Court of Justice, is that first you have an opinion provided by a so-called Advocate General. And the Advocate General gives a balanced discussion of the case and gives the courts recommendations how the Advocate General thinks the case should be decided. In most cases, the court follows the Advocate General because the Advocate General has a number of assistants and takes very good care to look at every potential implication. And it often takes a number of months until an Advocate General delivers this opinion. However, in copyright law, for some reason, over the last 5, 6, 7 years, almost in 50% of the cases, which is very unusual, the Court of Justice didn't follow the Advocate General. This is very, very unusual. In most cases, 90% of the times, the Court of Justice would follow the Advocate General. So this is a very, very weird appearance. And when fundamental rights come in, especially the question how you balance them, the Court of Justice might have, in the end, a different appreciation of the facts. So I can only, because they haven't been decided, present you the opinions of the Advocate Generals. And in this case, all opinions were provided by one Advocate General, which is the highest of the Advocate Generals currently, the Polish Advocate General Maciej Spuna, a very nice guy who has now taken the habit, because he can distribute the cases, to take all the copyright cases on his desk. He gives the opinions on literally all the copyright cases over the last years. And he's a very, very smart man. You have a question?
I was just wondering, so you said that the Advocate General's opinions have not been followed in the copyright cases lately.
Yeah.
That's the case, and yet the Advocate General has kind of been taking on various copyright cases. So how is just curious about what's going on over there?
Well, it might be personal preference. It might also be that the Advocate General has, so that most a number of Advocate Generals. Okay, right. So before, even those cases that weren't given an opinion by Maciej Spuna have been provided by other Advocate Generals like Trysteniak, Sausman Skart-Oye, the Danish one, and there was a third one, Advocate General Bott. They all gave opinions, but the Court of Justice tended to overrule them. It's not overruling in the technical sense, but they ignored them often, quite harshly. They might just have a different idea how copyright should operate. They might be a bit more libertarian. They might be more user-friendly. There was one famous opinion by Advocate General Bott where he argued quite fiercely against an overly strict application of copyright law. He said, no, we need more liberty for users. They need to be able to, for example, use books in a library in digital form. The Court of Justice ignored that. There was only one case where the Court of Justice had a more libertarian approach to copyright law, and this was under the Software Directive on the question of exhaustion of digital software. Otherwise, more than 50% of the cases, the Court of Justice disagreed with the Court of Justice. Why that is so is a very good question. There are a number of research projects that try to really go into the individual arguments, but this is a tedious work. So what I'm currently doing with a colleague of mine is we quote all the judgment and all the opinions and see whether we can empirically discover a certain trend by Advocate General, by type of case, but
not yet emerged.
It could be variable, just highly subjective.
Sure.
Because the Advocate Generals often have a specific background, a flavor. If you have a constitutional lawyer, they might say copyright isn't that important. If you have a private lawyer, they might think about that differently. And one thing that could also influence this, and this a colleague of mine has argued here, the opinions are pre-drafted by referendairs, by assistants. And these seem to have been 3 different referendairs, which you can see by the way the footnotes have been drafted.
Okay.
And even the referendairs could have a certain opinion, and the Advocate General might say, I'm convinced by this one, but not by this one. So they have a certain power. So it's really the workings of the Court of Justice, how the Court of Justice operates internally. Okay? But in this case, it was certainly Advocate General Spuder who took the cases, but most likely 3 different referendars. But the way I know the Advocate General, he took very good care in putting his personal stamp on it. Most importantly, which is very, very unusual, you have 3 cases that had almost identical questions. Some of the questions, because they were provided by the same court, the German Federal Supreme Court, on the very same date. 3 of the questions in all these cases have the exact same wording, save for certain exceptions. Which would normally happen is that the Court of Justice joins these cases, treats them as one, to save time, to save resources. So the Advocate General then has the choice to say, instead of providing 3 opinions, I provide 1 big opinion, which often happens. Here, and that surprised me in the beginning, and now I understand why, Advocate General Spooner said, I leave the cases separately. I want to treat them one by one because they are based on 3 very distinct set of facts. The first case is the case of Funke Medien. In Funke Medien, you have a German newspaper who acquired, through some source, secret military reports of the German mission in Afghanistan. Where troops are located, how do they patrol, where they move, who is involved, what happens on a daily basis. Sorry. These secret reports are usually provided to certain ministries and certain members of parliament, but they are confidential. They are provided in redacted version, in a lighter version, to the entirety of the German parliament, and they are public. So you have access to certain information, but the confidential reports are not supposed to be leaked to the public because they can, so the German government, contain information that could endanger the safety of German soldiers. Through some channel, this newspaper acquired thousands and thousands of documents of these military reports, the secret versions, and put them on its website. Arguing, if you want to have information on what's happening to our military in Afghanistan, do your own research. These are important documents. You should be allowed to know what's happening to our troops in Germany. And you could never say that German press isn't liberal and doesn't have access to information. We know more or less what's going on with our soldiers in Afghanistan, but of course there are certain things that you can very well argue shouldn't be available to the public. Certainly, where soldiers are moving when, because that would of course give parties that are interested in harming these soldiers a fair game. You know, they would be able to predict where a patrol would be going, and they could attack it. And there was a similar problem with Fitbits of American soldiers. When American soldiers were jogging on their base, and you could on the internet realize, oh, there's an American base, and this is where the soldiers are running. So now American soldiers are barred from wearing Fitbits while they are on duty. Okay, very practical problem when you talk about availability of data and so on and so forth. But this wasn't the main problem here. The problem was, is a newspaper allowed to publish military reports on its website? And of course you can argue this is a problem of confidentiality. But what the German government did was it invoked copyright in these reports. It said what the newspaper has been doing is a violation of our copyright because it communicated to the public the reports in which the German government holds the copyright. It's a very, very weird defense because you could rely on confidentiality. Probably why they did it is because they had a very weak case on confidentiality and they didn't want to argue that in front of a court of law. So this is why they resorted to copyright law, filed an injunction to get the documents off. Another argument could very well be that the injunction in copyright was quicker to get than an injunction based on confidentiality. Yeah.
Professor, but especially in these cases, I'm not sure about how it is in Germany, but isn't the defense of national security or say security integrity of the nation defense which can be availed? Because generally the courts tend to take a lenient footstep when it comes to these larger principles.
I fully agree with you. I don't know why the German government didn't raise it. If you go through the entire trial, when they first argued in the German courts, they never raised confidentiality. They only raised copyright law. There must be something. Either it's too sensitive, they don't want to raise it, but they never relied on confidentiality. I really don't know why. Maybe they know who leaked it, and that would then become public. But I don't know. It's not apparent from the file. So they did rely on copyright law, and the Advocate General then had to decide in this case. And of course, there is no exception in the Information Society Directive, and therefore national law, that allows explicitly for the leaking of secret military reports. You would have to find a limitation exception that would apply to this situation, that would then exempt you from liability for communicating these works to the public. There is a quotation exception, and you could very well argue that they quoted these 1,000 pages of military reports. But as I told you, the quotation defense has to be interpreted quite narrowly, and it only relates to certain excerpts of work, and usually doesn't allow you to copy an entirety of the work. So, prima facie, there was no exception that applied, and they couldn't rely on one. And we don't have a fair use defense that would allow us to argue freely under European copyright law. So the question was then in front of the Court of Justice, would maybe the general notion of freedom of expression, which includes the right to provide information, justify an exception outside of the Information Society Directive, outside the exact wording of copyright law? Could you come up in certain cases ad hoc with an exception based only on fundamental rights, based on a constitutional value? And this would, of course, undermine the structure of European copyright law, because insofar we know exactly you have one mandatory exception, 20 voluntary exception, and no more. And the Information Society Directive says explicitly the Information Society Directive is exhaustive. There cannot be any more exceptions in the national law, which also might suggest that there shouldn't be an extension of the list by interpretation through the judiciary. And if there is any judiciary that could provide more exceptions, that is the Court of Justice. And national courts shouldn't intervene here. They first have to ask the Court of Justice whether they can rely on fundamental rights to effectively set aside copyright. And here Advocate General Spooner did a very, very creative thing, which, to my knowledge, none of my copyright colleagues, and they are all quite good, came up with. So we argued for a very long time with Jonathan Griffiths from Queen Mary, Christoph Geiger from Strasbourg, Lionel Bentley from Cambridge, how we would decide the case. And we never had this idea. Some of the finest European copyright scholars, I am none of them, didn't come to this conclusion. But Advocate General Spooner said, this is a very weird situation. Because normally when you deal with copyright law, you deal with private parties. You know, music company against a 12-year-old boy copying music in his bedroom. Okay, that's a standard copyright case. But here you have a government that tries to invoke copyright law. But the idea of fundamental rights is that there are rights for the citizens as against the state. Citizens can invoke fundamental rights against the state. So in the first place, the state shouldn't be allowed to rely on fundamental rights in property against the citizen. Because especially property right has traditionally been a right against expropriation, right? Against taking away something by the state from a citizen. If you look into international investment law, it's always a defensive right. You shall not take something away from me that I own. And the state, in that sense, isn't a person that can be expropriated, legal or natural, of course. And Advocate General Spooner said, my first argument is, if you're a state, you shouldn't be able to rely on copyright as a fundamental right. This is just taking fundamental rights too far. But he said, even if that was the case, we have to balance these rights carefully against each other, property and freedom of expression. And in order to balance these rights, we have to understand what these rights actually mean. What is the substance of the right to property? What is the substance of copyright law? What we call the subject matter, the core of copyright law. And he said, copyright is an economic right. Number one, it protects the author. The German government wasn't the author of these reports. It was merely the right holder, if anything. He also said that military reports aren't protectable at all because they aren't original, but that was a very technical argument. But he said copyright isn't there to protect the information contained in something. Copyright protects expression and not ideas. And therefore, invoking copyright to protect confidentiality is not within the scope of the protection of property as a fundamental right. You can only invoke it as a property right and not as a confidentiality right. Okay? So, and even if that was the case, in this particular instance, you still have to see whether freedom of expression would outweigh the very, very vague argument on property and the strong element of freedom of information. And here the Advocate General said, in this case, the balance clearly falls on the side of freedom of expression. So you cannot use your property right to keep the information secret. However, he said very interestingly, relying on jurisprudence by the Court of Human Rights in Strasbourg, Council of Europe, that there might be very exceptional cases where that should be possible, but not when it's a state, and not when the state pursues something that is not protected by copyright, namely keeping information secret, but not the precise expression. They can rely on something else, ideally public policy, public security, but not copyright. Okay? Therefore, he kicked the entire case out of the court, saying copyright doesn't really apply here, we should ignore it. Hand it back to the German court and tell them, if you want to keep the information secret, you have to find something else, but please don't make a copyright out of it. And I think this is a very, very elegant and sensible way to get around that problem. And implicitly, he also teaches us a very good lesson what copyright is all about. So by now, I always give my students this particular opinion because it gives you a very good introduction to European copyright law. What is protected? What are limitation exceptions? When do they apply? And what role do fundamental rights play? So if you read one of the three opinions, certainly read this one. Okay. The second of these cases is my favorite because this is my strongest area of expertise, the Pelham case. The young gentlemen here on the right side, I know they look quite creepy, are a German electronic band from the 1970s. Pioneers of electronic music, the band Kraftwerk, who have been sampled thousands of times by other artists. And of course, if you know a bit about copyright law, whenever you want to use something that has been created by somebody else, even a small part, you have to ask for authorization. And especially when it comes to music production, sampling is economically a quite viable field. Because if you look into any piece of music these days, they all contain samples. Hardly anything is original anymore, certainly in pop music. So in the late 1990s, the German hip-hop producer Moses Pelham created a song Nur Mir for a hip-hop singer, Sabrina Setlur, that used a 2-second sample that was based on the song Metall auf Metall, Metal on Metal, by this electronic music band. And that went quite quickly to the German courts, with the effect that the German courts issued an injunction that that song could not be sold or played anymore. And that was in the early 2000s. So since the early 2000s, the first judgment was handed down in 2004 by the court in Hamburg. That song is barred from being sold and played. You find it on YouTube as a video, but in principle there's an injunction standing against the playing of this song. Mr. Pelham, who's quite a notorious artist, he has been fighting brawls and everything, but he did a lot for copyright law by initiating these claims, because he had argued towards the end of this litigation, what I have been doing as a producer of hip-hop music is I exercised my freedom to artistic expression. Hip-hop is my art, and therefore I should be allowed to use pieces of other artists. Because historically, if you look at art, it's all about copying. It's about copying themes, it's about copying melodies, it's about copying images, it's about copying constellations, it's about copying styles and colors. And therefore, if I want to exercise my art as a hip-hop artist, I must be allowed to copy. Because the essence of hip-hop music is to make reference to other artists. Otherwise, hip-hop wouldn't work. This is what this entire genre is about. And you can argue the same about pop music, you can argue the same about classical music. They constantly lends and borrows from other genres, but also within a genre. There's a very interesting book recently published by an Israeli scholar on particular this element, that copyright, and especially derivative works, should have more regard to the actual reality of creation. And this is what this case is about. What made the case more complicated is that Kraftwerk didn't only rely on its copyright proper, but they relied more intensively on the right to their sound recordings, which is a related right. So in copyright you have first of all the right to the work, to the intellectual creation, but if you then produce a record, as a record producer, not as the author, you also have the right in the particular sound recording, in this particular recording session. So if you then take a sample, copy from a particular record, you not only violate the copyright, the expression of an idea, but you also violate the sound recording right. Okay? And the question here was more about how do we interpret the sound recording right? Would it allow the free taking of a 2-second sample? And in German copyright law, we have a very weird creature, which isn't contained in the Information Society Directive, which is the so-called free use defense, which isn't fair use, but the free use defense says that you are allowed, under certain circumstances, to copy an existing work, to use it in a new work, if the old work disappears behind the originality of the new work. Okay? It is quite flexible, but under quite strict conditions. Okay? And here Mr. Pelham argued, I used this 2-second sample as a loop in my song, but nobody, certainly nobody from my audience, would realize that this has been taken from the Kraftwerk band. But indeed, if you listen to the song, throughout the song, you hear that sample. If you know where that sample comes from, you realize it. So the German courts struggled with this for many, many years. And they also said that if you have a sound recording, even if you take half a second or a tenth of a second, you still violate the sound recording. And the free use defense shouldn't apply in this case. Okay? Because it's a sound recording and not a copyright protected work. A very strict interpretation of copyright law. Until the case came, a copyright case, came to the German Constitutional Court. And the German Constitutional Court, taking a case away from the Federal Supreme Court, a civil court, said, Mr. Pelham is right. This is artistic expression. And in some way you should allow him to be creative. But if you prevent him from using a sample for free, if this is dependent on the will of the right holder, he might be blocked from being creative, from exercising his profession, his creativity, because the right holders don't want to give him the sample for free. And even if he could ask them and would be willing to pay money, it is a process that would delay his creativity. Because if he uses multiple samples from different artists, you would have to ask up to 20 artists for not only permission to use the work, but also the sound recording. And this is an administrative work that would prevent, that would deter creativity. I was in a workshop once of a Danish band that created works only based on samples, and every single song they created had always more than 1,000 samples. They just took things they found in records from Malaysia, from New Zealand, they bought in thrift stores, digitized them, and then they created songs from them. If they were to ask all these artists, they couldn't create music. But they say they're artists, this is what we do, and therefore we should be allowed to do that. That's what the German Constitutional Court said. Somehow it should be allowed. Even possibly via a system of mandatory licensing, where you would have at least one point of contact, collecting society, where you can go and acquire a license. But you shouldn't be required to ask that particular artist. Because then the artist could say, I will not give you the sample. and then you couldn't create anymore. It handed the case back to the Federal Supreme Court, which then referred the question back to the Court of Justice, which had already been told to the court by the Constitutional Court, saying this raises question of European Union law. You might want to make a reference to the Court of Justice. But the message from the Court of Justice, from the Constitutional Court, was we should allow this. No? This, under a German interpretation of the freedom to artistic creation, should be permitted. Sampling of 2 seconds is covered by the right to artistic freedom. And now comes Advocate General Spooner. And he says, yes, we have to find a balance in copyright law. But it is up to the legislator to define that balance. And if the law, Article 5 of the Information Right Directive, doesn't foresee free sampling, that's it. You cannot sample. Unless you find within the exceptions an exception that could apply to sampling, for example, quotation, then you cannot sample for free. And he went through all the exceptions and looked at parody and looked at quotation and couldn't find them too applicable in this case. He argued very well, yes, it is a case of freedom of expression. It is covered by this. But the European legislator made the decision that sampling is not covered by an exception under copyright law. And therefore, you are not allowed to sample for free. Which means, in essence, you have to ask an artist if you want to use even the smallest part of a sample. Because in part of his opinion he says, he interpreted the rights of a phonogram producer to mean that even if you take the slightest part of a phonogram, it's still copying. Even if it's a hundredth of a second, that still requires authorization from the right owner. It's, in essence, a stronger right than the right of the author. You had a similar case recently in the United States of America, the VMG Celso versus Ciccone case, where Madonna had used a sample from another pre-existing song. And the 12th Circuit Court in California argued differently. The court argued that you couldn't have an interpretation of the scope of the phonogram producer's right that would undermine the fair use defense. That would make the fair use defense as applied to works in this particular case more or less redundant, and thereby opposed another circuit in the United States of America. So even in the States, this is still a pending question, and most likely will at some point end up in front of the Supreme Court. But here, Advocate General Spooner says, and that's the last instance. In the EU, we interpret the sound recording, the phonogram right, very strictly. And if you want to use a phonogram, you have to ask for permission. Which doesn't mean, however, that you cannot take the phonogram, replay it yourself, recreate the sound yourself. And then it's not copying the phonogram anymore. Then it's just copying the work. And that could potentially be caught by another exception. But it certainly wouldn't fall under the relatively strict application of the phonogram producer's right. And this is exactly what the German Federal Supreme Court had said before. You cannot sample, but you can recreate. You can go to your own studio and try to create the sample yourself. And then you don't infringe the phonogram, but you then only infringe the work. But the protection of a work is slightly different in scope than the protection of the right of the phonogram producer. And this is also what the Federal Supreme Court then later had suggested to the Court of Justice as one option. But Advocate General Spooner strikes down both options. He doesn't go with a relatively liberal interpretation of the phonogram producer's right, but he also doesn't suggest that there is an exception available. And he also says that one of these fair use-like defenses is incompatible with European Union law as it stands currently. Because you have this very long discussion in the European Union for the last couple of years whether we should introduce a fair use defense. Every single year somebody writes 5 or 6 articles. We should have a fair use defense in the European Union, particularly because of these cases here, particularly because European copyright law is slightly outdated, and particularly because it doesn't seem to provide sufficient room for freedom of expression. Because there will always be cases, two of them we have already discussed, that would suggest that freedom of expression should be given more liberty in copyright law. Yes.
Go ahead. I just had a question with regard to the fact that you said that earlier the right to adaptation of a particular work is not covered under copyright law. So wouldn't allowing the recreation of an existing work be a type of a loophole against protecting the original author's work, as opposed to merely sampling it, which is a very small component of creating it in your original work? So reconciling that with the fact that copyright is in essence a protection of economic rights, and retrieving permission from every individual original author would in fact hinder the economic rights of the subsequent producer. So how do you reconcile those two aspects?
That's a very good question. The answer would probably be, so there are derivative rights in every national legal system, but they don't have a harmonized scope. And derivative rights are very, very complicated because they largely overlap with the reproduction right that is harmonized at European level, which means that the reproduction right would then radiate into the area of the right to make a derivative work. So you would have to interpret the derivative work rights in the light of European law nevertheless, because it overlaps with the reproduction right. This is why it would be so complicated. Okay? So in this case, if you only talk about the work and not the phonogram, you could make a good case, because you do have a bit of flexibility when it comes just to the work. Because the standard is originality. As long as you don't copy the originality of a work, you are allowed to use that fragment. But the second you have a related right that plays into it, you have a problem. Because the related right is covered by harmonization, it is covered by European Union law, and therefore you have a uniform interpretation. But I mean, ideally we at some point in time harmonize the derivative work right. And there are also people who argue that the derivative work right is indeed implicitly harmonized by the reproduction right by defining its scope. So everything that's not covered by the reproduction right, you can use in a derivative way. But we don't have any official statement on that. This is just how we interpret the rules under European copyright law. But I mean, if you want to write a paper on that, there you go. I wouldn't do today that right now.
Professor, you said something about the case in the US,
Yeah.
where the court provided that if you go to the studio and reproduce the song, the sampling yourself,
Yeah.
then that's not a violation of the phonographic rights. Hasn't the court then essentially made the rights with regards to sampling for the labels that produce illusionary then in that case?
Only to a certain extent. If you take large chunks out of a song, that would still constitute infringement. So the court in California only said, essentially it applied a de minimis rule. If you take a short sample that would be covered by the fair use defense, the phonogram producer's right shouldn't block this fair use. But if something isn't covered by an exception, you still have the phonogram producer's right applying. Okay, you might know the Bridgeport case, no? Which is a case from 2006 in the US, which said the exact opposite. So these are the two clashes. The Bridgeport case essentially what Advocate General Spooner says. Taking anything from a phonogram is a prima facie copyright infringement and cannot be excused by the fair use defense. Because the fair use defense supposedly doesn't apply to a phonogram producer's right, but only to copyright proper. The California court was slightly more liberal. Where that ends up in the end, we don't really know. Any further questions? Okay, so then we go to the last case, and this is kind of like a clean-up case then, because Advocate General Spooner says quite precisely, I've covered more or less everything in the first two cases already. In the last case, we don't have much to argue anymore, but it nevertheless is an interesting case because it covers a different facet of freedom of expression. This slightly elderly gentleman is a German parliamentarian, or used to be a German parliamentarian, Volker Beck from the Green Party. And he spent, I think, 12 or 16 years in the German parliament. And before he became a member of parliament, he published a number of articles. And he also published an article in 1984, I think it was, where he mildly suggested lowering the age of sexual content for minors. Okay? Suggesting that even if you're 14 or 13 years old, as long as you agree, somebody could have legally sex with you. And this is, of course, outrageous, even today. Nobody would say that this is okay. This is just tasteless. But if you read his article, you could come to the idea that this is what he wanted to say. So he argues that he wrote this article and gave it to the publisher of the edited volume in which it was supposed to appear. And he says the publisher changed it and also changed the message, distorted what he wanted to say. And he never wanted to say that. And everybody said, okay, if he didn't want to say that, the publisher might have just, shot slightly above the aim, and he's actually a nice guy, Mr. Beck. But as it happened, while he was a German parliamentarian, somebody discovered the original manuscript that he had written in the archives of a foundation which is very close aligned to his party. And they took the manuscript and compared it to the actual text and realized everything that had been changed were 2 titles. And they didn't really change the message at all. Yes, there were changes, but they were more of a technical nature, but not in terms of the intention of the message of the thrust of the article. So indeed you could argue, he said, you can have sex with children. That's an exaggeration, but even the way he said it is highly controversial. So Spiegel, one of the biggest German news outlets, published the manuscript and the original article via hyperlink, and also had a short article saying, these are the 2 documents, look for yourself what you think about them. Our opinion is that the published version isn't much different from the manuscript, and therefore he was lying all the time. At the same time, Mr. Beck had published on his personal website as a parliamentarian the published version, and with a watermark had over every page written, I distance myself from the article. Okay, he said, this is not what I wanted to say. And he also published his original manuscript. Both were available on his website. But Mr. Beck then sued Spiegel Online, arguing, what you are doing is copyright infringement. It's also a weird case, right? Why do you write in a copyright when everything you want to be taken down is the information? But he said, you are communicating my work to the public, please take it down. Now, this is, I haven't authorized you. And Spiegel Online said, we are a media publisher. We rely on the freedom of free press, also essentially covered under Article 10, respectively 11 of the Convention and the Charter. We should be allowed to do that. And in any case, we are merely quoting. We are quoting entirely, but what we do is we are quoting. And then Advocate General Spooner gave his opinion, and he said, number 1, what Spiegel Online was doing was not a quotation, because as we discussed before, a quotation usually refers to excerpts that are linked and integrated into news reporting. Okay, so you can take a sentence, maybe 2, but not an entire work. This is not quotation. Okay, this is absolutely out of the scope of that defense. But we have to look at the case in particular. If we balance fundamental rights, we have to see whether in this particular case the right to freedom of expression should overrule copyright law. And he just looked at the facts and said, was it necessary, and the Senate is in a democratic society, that Spiegel Online published this information? Because you can only infringe upon the right to freedom of expression if it's necessary in a democratic society. Okay, you can turn it around. Was it necessary for Mr. Beck to prevent the publication of these articles? So you tilt these fundamental rights against each other. And he looked at the facts of the case. He said, could you as an individual get the same information without the publication of the documents on Spiegel Online's website? Or, the other way around, could Spiegel Online have achieved the same result without copying literally, without communicating literally the articles written by Volker Beck and as published in the edited volume? And they say, and Spooner argues, the documents were available anyway on the website of the parliamentarians. So what the newspaper could have done, it could have just linked to the website And linking is not an infringement of copyright in most cases. And they could have achieved the same result by that. Spiegel Online, however, still argues is that the fact is not the same. Because on the website of Volker Beck, of course, you have an accompanying text and you also have the watermark, which you didn't have on the Spiegel Online text. And there you would be biased immediately as to whether there is a different message or not, because he distanced himself from that particular message. And this is why Spiegel Online said it was necessary that we publish this. I probably would say Spiegel Online is correct, because other argument is that if Mr. Beck now decides to take down these articles, then the hyperlink doesn't work anymore. Then you are not able to compare these two. But that might then again change the case. That then again might entitle you as a press publisher to publish these articles if you are the only reliable source of information. But this is nothing what Spooner took into consideration, because these aren't the facts that are in front of him. Okay? So here you have a scenario that with time might actually change. If Mr. Beck takes down these articles, Spiegel Online might be allowed to publish them. And Spooner also takes into consideration that yes, Mr. Beck is a public politician. No? We should be able to know about him. But he also says there's not a right to know everything about a politician, especially if he himself provides a certain degree of transparency. And that wouldn't allow a newspaper outlet or a media outlet to infringe his copyright. Okay? Only if the information wasn't available otherwise. And even then you would have to argue. But again, there was no defense available under copyright proper. And if you want to find one of these extreme rare cases that would overrule copyright, you have to argue very, very expertly. In this case, in his opinion, that hasn't happened yet. But as I said, the Court of Justice will have the last word, and we know the answer probably in May, if not in May, sometime in September. And although the cases aren't decided yet, what consequences does that have for European law copyright at a larger scale? What Spooner says in principle is what many European copyright scholars are wishing for, a fair use defense. It's not possible because it wouldn't provide sufficient legal certainty. Okay? And it would destabilize the European common market. I explained to your colleagues already, the idea in Europe is that you have similar rules everywhere, in every member state. But if you open up a fair use norm, which is interpreted by the courts, you might have different standards in France and in Portugal and in Poland and in Germany and in Denmark. And this is nothing that really works with European Union law. Okay? It might work in one particular country where you have a final jurisdiction, but not in the European Union. That might create a more disharmonized copyright law throughout the European Union. But what you can read in the case is that Advocate Spooner himself is very uncomfortable with how European copyright law is structured and that it is outdated. So he, by giving his opinions, more or less tells the legislature, please change copyright law, because it clearly doesn't really work anymore. Interestingly, we are currently in the midst of a big European copyright reform, and none of these aspects are being addressed right now. So there are certain new limitation exceptions foreseen, but one is for text and data mining, which nobody really cares about. One is for conservation purposes by cultural heritage institutions, and one is for cross-border educational users in the European Union. But nothing talks about music sampling, press reporting, or leaking documents. But most importantly, the proposals also don't argue why they don't address these issues. Why we don't have a stronger flavor, a stronger support for fundamental rights in European copyright rules. This is completely absent from the discussion at policy level. At the sub-policy level, people argue all the time about that. Okay, there have been so many initiatives that argue we need more flexibility in copyright law, in whichever way. And only a couple of days ago, Christophe Gaguerre, one of the best copyright scholars in the EU and probably in the world, argued we need an open norm that is based on fundamental rights, because he had read these opinions and he widely agrees with the approach but not the outcome. Okay. Most scholars, by the way, disagree with Advocate Spooner on the interpretation of the sound recording rights. Lionel Bentley from Cambridge says this is nonsense. He tweeted that quite vocally. And I think the most important element of Advocate General Spooner's opinion is that although we have this closed list of limitation restrictions, there will always be cases that a legislator cannot foresee where fundamental rights other than property have to be given effect. But these cases are very, very limited. And we haven't found one of these cases yet. Because the balance between property and all the other fundamental rights should be obvious, should be foreseeable. They should be subject to legal certainty. And only in very, very rare cases could we balance fundamental rights outside existing copyright rules. You can technically do that, but you have to find a very, very weird case in which that would be possible. Whether one of these cases will ever come in front of the Court of Justice, I'm quite pessimistic. I don't think that will happen. Okay? But in these cases, we have to see how the legislature now reacts, whether last minute or in the next 5 years, they will come up with a new system. Because the one that we have since 2001 certainly doesn't give enough room for fundamental rights, for creativity, for news reporting. And literally everything that has to do on how you disseminate information on the internet. There was one big discussion whether we should have a special exception for internet memes, because they, of course, also always copy something. In the US, no problem under fair use. In the European Union, they're technically all illegal. They're up there because nobody enforces them. They're sometimes even beneficial for the right holders, but nobody enforces them. This is why they're still out there. But in principle, they're in violation of copyright law. You could very well argue parody or critique, but that would be a very, very hard case to make. So in essence, the legislator makes a decision, and therefore the legislator at some point should act to make sure that the balance is maintained in copyright law. Because over the last years, you always had certain additions and more restrictive interpretations of the exclusive rights, which of course then makes limitation exceptions a less strong element to create this balance. And of course you also had increasing ISP liability on the enforcement level, which distracts from the rights of the users. But again, it's up to the European Parliament, the European Commission, the European Council, the legislators, to strike this balance now. Because the national courts aren't supposed to do that, and the Court of Justice still has to operate in order to maintain harmonization and legal certainty within the rules provided by the legislator. Any questions? No? Nothing? All right. Maybe we had some questions in the meantime already. If you have questions afterwards or in the future, by all means do send me an email. Look what rubbish I distribute via Twitter, which is, by the way, really, really good for copyright law, because in that sense you have a very, very strong community of excellent scholars. The last scholar that joined Twitter that was relevant was Christoph Geiger around 8 days ago. Okay, we finally got him on Twitter, and he's now really, really active and shows everything that he's working on. It's an incredibly useful resource for copyright. Okay, for many other things it's utterly useless, but this is where you get, especially on ongoing discussions, last-minute information. And if you follow, Samuelson from Berkeley, now Geiger from Strasbourg, Bentley, they put there's one more scholar who isn't on copyright, Bernd Hugenhaus from Amsterdam, but he's too old for that. Everybody else is on there, and if you need anything on IP-related actualities, this is where you get literally most information. I never thought I would say that, but it's true.
Yeah. I have a question. Why don't we talk about the difference between free use and fair use?
We talked about that briefly, yeah. So you know what the difference is in essence?
I'm not exactly sure. So we have, as a matter of our course, we've done fair use, but I'm not entirely sure what free use can constitute. So you could try me.
Yeah, so this is why I always put free use in inverted commas and say it's a German defense. So fair use, we have the 4 factors, right? Essentially, transformation is the most important one. And then you also have the economic impact, which means fair use covers a large variety of instances. Google Books, successful fair use. Campbell Acuff Rose, successful fair use. You have all the Prince cases, successful fair use, I think save for one, no? Where people took large cases, sometimes entire books, to transform them, give them a different purpose. Free use means kind of like the opposite. You can use a short extract if the short extract disappears behind the originality of the new work, so it more or less becomes invisible, then you can use it. And it only applies to certain categories of works, okay? And only for certain purposes. This is the German free use defense. But that was still ruled to be incompatible with European Union law as long as it doesn't fall within one of these 20 exceptions in the Information Society Directive. Okay? Because you always have to interpret. So when you implement national law, European law into national law, you don't just have to copy it, but you can give it a different wording or a different structure as long as you achieve the same result. So you could apply free use as long as you stay within the exceptions of European Union law, but the wording of free use is still relatively restrictive. So if you use a sample, the idea is that you don't recognize the sample, or it's a very unimportant part. If you use a part of an image, it should disappear beyond the larger originality of the new work. This is the basic idea of the free use defense. So fundamentally opposite to fair use, which allows you a large scope of freedom, and free use is very, very limited.